Currently in the media, there's a plethora of legal-based TV shows like Suits, Law & Order, and CSI. These shows are all produced by American-based companies, and as such, people who watch these shows see a dramatization of the American justice system instead of the Canadian version, and therefore lack a solid foundation of our country's criminal trial process. In order to help combat this, I've prepared this presentation to help educate today's Canadian youth of Canada's trial procedures. Most proceedings in Canada are heard solely by a judge, and as such, there are usually only 3 main courtroom roles. However, in trials by judge and jury, there are 4. The Crown, the defense, the judge, and the jury. There are other roles aside from this too, such as the judge's deputy and the bailiff. The Crown and defense are the lawyers of a case, whereas the judge and the jury are in charge of reaching a verdict, where a judge hands down a verdict in a judge-only case, and the jury gives a verdict in a judge and jury trial. The Crown represents the government and society's best interest, meaning their job is to obtain a conviction if there is a reasonable chance that the accused is guilty, and withdraw the charges if there is a strong chance that the conviction will not be reached. The Crown's ability to drop charges at any time is called prosecutorial discretion, and is a strong feature of our justice system that sets Canada apart from the American system. It should be noted that the job of a Crown is not solely focused on obtaining conviction, but instead on laying out all the evidence that can be used to prove the accused's guilt, and to be a representative of justice. The role was probably best put in the 1955 Supreme Court case, Queen and Boucher, where it was stated that the purpose of a criminal prosecution is not to obtain a conviction, it is to lay before a jury what the Crown considers to be credible evidence relevant to what is alleged to be a crime. Counsel has a duty to see that all available legal proof of the facts is presented. It should be done firmly and pressed to a legitimate strength, but it should also be done fairly. The role of a prosecutor excludes any notion of winning or losing. His function is a matter of public duty that when in civil life there can be none charged with greater personal responsibility. It is to be efficiently performed with an ingrained sense of dignity, the seriousness and the justness of judicial proceedings. The defense, on the other hand, represents the accused. Their job is far more partisan than the Crown's, as their goal is to obtain an acquittal for their client to the best of their ability. They represent the accused in the trial, and use only the evidence that will raise reasonable doubt of their client's guilt in order to achieve an acquittal, or at the very least, a lower sentence. The defense has a wide array of potential arguments that they can use to prove that their client is not culpable, such as the defense of necessity, self-defense, or duress, to name just a few examples. Generally, the defense gets to be far more creative in their approach than the Crown. The judge is the impartial third party who hears all the evidence given, determines its credibility, and listens to all the arguments made in order to render a decision of guilty or not guilty. In judge-alone trials, they also act as a referee, making sure that all parties in the proceedings abide by courtroom procedures, and also decides on the validity of objections brought up during the trial. In a trial by judge and jury, the judge has a much smaller role, simply instructing the jury on the law before they go to make a decision, as well as acting as a courtroom referee. The judge also makes the decision of allowing or disallowing the use of evidence during voir dire, which is a trial within a trial, regarding the admissibility of a piece of evidence in court. The jury also appears in judge and jury trials. They represent a cross-section of Canadian society and are composed of 12 members aged 18 and above. Jurors could not have been found guilty of indictable offenses at any time in their lives preceding their trial, and cannot be involved in law enforcement, the study of law, or be a doctor or veterinarian. Prospective jurors are chosen off of a voters list and then brought to court for impaneling, where the defense and Crown challenge, which means to remove, certain prospective jurors, either using a challenge for cause, which is a challenge based on potential bias found within the juror, or a peremptory challenge, which is a challenge for no reason. However, each side only has a certain amount of peremptory challenges per case, a number that increases as the severity of the charge increases as well. The jury listens to all the evidence given at trial, hears the arguments, and formulates a verdict based on the decision. For a guilty verdict, all members must vote guilty. If there is even one person who votes not guilty, then the accused is acquitted, as this means that there is still some reasonable doubt to their guilt. The bailiff acts as a security guard of sorts to the courtroom, ensuring that the accused is secured in his or her seat, and ensuring that nothing dangerous enters or is used in the courtroom. Their duty is to protect everyone inside the courtroom. The judge's deputy acts as an assistant to the judge, delivering to them files and helping them through their duties in court. They can also deliver water to those who need it inside the courtroom. Other roles do exist in the courthouse, such as the courtroom recorder, who records every word that is said in the trial for case law documents. However, the ones listed are the main ones. The Canadian justice system is centered around the topic of the presumption of innocence. This means that the accused is presumed innocent until proven beyond a reasonable doubt that they are guilty. Therefore, the Crown must go first, as they have to show why the accused is guilty in the case using evidence. Since it is up to the Crown to prove guilt, the burden, also known as the onus of proof, resides within them, meaning that they have to bring up relevant evidence to the case in order for a trial to happen. If the guilt beyond a reasonable doubt cannot be proven, then the accused is acquitted. And during a trial, evidence is brought up through a variety of forms. The main form used is direct evidence, which comes in the form of witness testimony, which essentially is a recount of what was seen or heard by the witnesses of the incident. These experiences must be first-hand. If they are not, they are called hearsay evidence and become inadmissible in court. Witness testimony comes in a variety of forms, including eyewitness, people who have seen the crime, earwitness, people who have heard the crime, and expert testimony, which comes from people who do not witness the crime, but are specialized in the knowledge of the details that the crime relates to, for example, a forensics expert. This information is gathered through direct examination, which is where a lawyer questions their own witness, and cross-examination, where the opposing counsel questions the other lawyer's witness to test their credibility and reliability by revealing contradictions of what they said then and what they said earlier. Questions must be relevant and cannot imply an answer during direct examination. However, in direct examination, this barrier is removed to an extent. However, these questions must be on topic to what was talked about during the direct examination, if they are leading questions. Questions which imply an answer are called leading questions. Indirect evidence links the accused to the crime scene, but does not prove that they committed the crime. This is also called circumstantial evidence. These can come in a variety of forms, such as physical evidence, which includes forensic evidence, which is basically evidence found at the crime scene, such as hair and fibers, as well as photographs of the crime scene, or DNA evidence, which is basically body fluids, hair, and nails, anything that contains the accused's DNA that can be used to link them to the crime scene. Evidence which was gathered illegally or may not be otherwise admissible may be allowed in specific scenarios where the action of not admitting the evidence would put the administration of justice into disrepute, shocking those viewing the trial because it was not allowed. During these scenarios, the evidence that would otherwise be inadmissible would be admitted. A voir dire is used to determine if a piece of evidence can be admitted if either side has qualms about it. Those principles are basically the gist of the Canadian justice system and trial procedures. Hopefully, this cleared things up regarding the differences between the American and Canadian courtroom procedures and rules. It is this system that is used every day in Canada to determine the truth, and is vitally important for all Canadians to understand in fears that one day, maybe they might have to go through it. Thanks for watching.